Welcome back. The Financial Intelligence Centre Amendment Act is now operational. The law that aims to prevent money laundering, tax evasion and other financial crimes had been signed into law by the President. But the commencement date was left to the Minister of Finance, who has now signed and gazetted its coming into operation. The law has travelled a long road. Initially, the President declined to sign the law, questioning its constitutionality. The first draft allowed for people accused of financial crimes to be searched without warrants. The President was later criticised for further delaying the bill when a deadline loomed. Without the law, South Africa would have been out of step with global regulations, and this could have resulted in some transactions with foreign organizations being restricted. The amendment law adds to the existing Financial Intelligence Centre Act, or FICA. It compels banks to monitor the accounts of high risk or prominent individuals in the country. For more on this, we are now joined on the line by Ismail Momoniat, the Deputy Director General for Tax and Financial Sector Policy from the National Treasury. Ismail, thank you so much for joining us. Now, what are the new provisions in this Act?
Well, the main provisions in this Act sort of relate to a risk-based approach rather than, say, the previous rules-based approach towards knowing your customer, or what's in more fancy terms called customer due diligence. So this means that on the one hand, it's going to be probably good for customers in that the system should be more friendly and not relying on, for example, say the old utility bills, which many people don't have when they want to open an account. It now allows some flexibility to the institution to look at better ways, depending on risk, on opening of accounts and so on. It also has provisions towards, as you said in the program, risk rating domestic, prominent, influential people who hold sort of political office or do business with the state, and also tries to look at the ultimate owners, or what's called beneficial owners of companies that may be your customers. So, in a sense, institutions who they have to know who they're doing business with.
Now, Ismail, what made these improvements necessary?
Well, firstly, that these have become international standards, and we have been lagging behind. And the international standards are driven by the fact that obviously cross-border crimes have increased. It started off with the drug syndicates, but has moved on, where, you know, for example, you had a former Nigerian president who stole $4 billion, Sani Abacha, and put it in Swiss bank accounts. And Nigeria struggled to get those funds. Anti-money laundering makes that a crime, that you can't commit a crime and take the funds and put it in another country. In the old day, in the early 1990s, it was impossible to get those funds back because there was bank secrecy, for example, in Swiss banks. These provisions now make hiding funds like that very difficult. These have to be reported as suspicious transactions and be reported to the Financial Intelligence Centre or its equivalent in other countries, and then can be given to the enforcement authorities.
Now, while this law provides for ongoing monitoring of sources of wealth and sources of funds of domestic, prominent, influential persons, their family members and close associates, can it be challenged in a court of law?
Look, anything can be challenged in a court of law, but whether you're going to be successful depends on, I guess, what legal arguments are put forward. Having said that, this law has been tested. As you know, it's been, as you said, a long journey. There's been lots and lots of challenges, and frankly, it's still come through, and I'm pretty confident though I'm not a lawyer, that I think it will stand the test of time against any legislative attacks against it.
There were other issues like searches without warrants. What were the problems with these searches and what has now changed?
That's a very small element in the investigation. It's related if a supervisor, particularly a private premise, when did he need a warrant, and if there was urgency, if they wanted to do a warrantless search, what were the circumstances? It's a pretty technical argument, but I think those things have been sorted out.
Now, Ismail, let's speak about the delays of the signing of the FICA Act into law. Has it been a source of anxiety for the Treasury?
Look, it's not been a source of anxiety, but we've obviously been concerned that we were put on a FATF watch list, or we were in danger of being put on a watch list, because we are one of the few countries now who are members of FATF who haven't these measures. And in fact, we'll be going to a meeting of FATF next week where we need to demonstrate progress. And had we, for example, not shown progress, we would have been put on a watch list, and and then there would be measures taken against us if we continued not to conform, because countries don't want to deal with countries that have lower standards and allow their system, in a sense, to become dirty with money laundering. I think now that we've done what we've done, now that the law's taken effect, I do think that it will be easy for us now to get out of the risk of being put on the watch list.
And now, when will the full implementation of the new provisions be adopted?
Look, some provisions of the bill take effect today, and some provisions will take effect on the 2nd of October. And then there's just a few other clauses which probably will be in place by the end of the year. So almost all the legislation will be in place well before the end of the year, in my view. The challenge is going to be in implementation, and that may take institutions a bit longer to fully conform with what the law intends, because it requires systems changes, it requires getting information from customers and so on, and that may take a bit longer.
Ismail, we'll have to leave it there for now. Thank you so much for joining us. That was Ismail Momoniat, the DDG for Tax and Financial Sector Policy at the National Treasury, joining us on the line.